In this presentation, we look at one technical element of criminal law and one rule for establishing crime. The technical element is the Actus Reus, whilst the rule is causation. Actus Reus is a bad act that constitutes a crime. This is an action or omission that creates an outcome that is criminal under law. The Actus Reus is a voluntary act that creates a state of affair that is criminal. In other words, Actus Reus is an activity that causes a crime. Actus Reus creates a distinction between a mental thought or idea and a physical action that creates the crime. Normally, a mental thought or fantasy is not punishable by law. The physical action or Actus Reus constitutes the basis of a crime. In R v. Quick, 1973, a person who suffered a condition of excess insulin in his blood assaulted another, and due to the fact that the assault was involuntary, the court ruled that the Actus Reus was not sufficient to charge him. Therefore, it is apparent that an Actus Reus must be an action. An Actus Reus could also be an omission. In the case of Greener v. DPP 1996, a dog owner who entered a park with his strong and dangerous dog left the dog chained in an enclosure. However, the dog was able to break the chain and escape to bite another person. The owner was charged under Section 3, Subsection 3 of the Dangerous Dogs Act of 1991, which considers such an act as an omission, which becomes the Actus Reus of a crime. Causation refers to the link between a criminal act and a person or entity to warrant a criminal liability. Causation tests the sufficiency of the defendant's conduct to justify whether they are liable for the crime or not. The causation aims at establishing the link between the defendant and the act or crime in fact and in law. Factual causation is about whether there is proof that the defendant actually did the act in question or not. Factual causation is done with a but-for test. In this context, it is established whether the act would have happened or not if not for the defendant's conduct or omission. Legal causation is proof that the defendant's act is sufficient to warrant a criminal liability. However, there are some things that limit the obligation of the defendant in terms of causation in criminal cases, including: Number 1, the victim's level of blameworthiness. Number 2, novus actus interveniens, the occurrence of new actions that render it unfair or illogical to charge the defendant.